Good evening. I'm Jim Zirin. Welcome back to Conversations in the Digital Age. Tonight we have a terrific show for you. With us is an old friend, Fred Hitz. Fred Hitz is a lawyer. He is a teacher. He is the former Inspector General of the CIA. And we're going to talk about intelligence. We're going to talk about the Snowden affair and its impact on the U.S. intelligence community. Fred, we're delighted to have you with us.
Nice to be with you, Jim.
Now, let's start with Snowden. Who is Edward Snowden, and how did he get access to so much information which is said to be damaging to the national interest?
Well, Edward Snowden is a new phenomenon in American government and the intelligence world in particular. He's a contractor. He does this full-time operative on U.S. government business, but not from the inside. He works for Booz Allen and Hamilton, and he has, as you know from the reports, been working actually in Hawaii, but on business that deals with the National Security Agency, one of our most secret and sensitive organizations. They used to call it NSA, no such agency, in the old days.
Possibly because they didn't want anyone to know it existed.
Didn't want anybody to know it was there.
Now, he had worked for the CIA. Now, so he must have.
Well, I'm not sure about that, Jim. I'm not sure.
I'm not sure he did.
No, I don't think he ever did.
But he had to get some level of clearance in order to work for the NSA, even as a contractor.
You've just hit the nail on the head. We have, in this country now, 1.5 million top secret clearances. They can be obtained by contractors to do this work. The whole notion is that we don't want to grow the federal government of permanent civil servants. We want to be able to meet issues as they arise and deal with it in an economical way. And contractors appears to be the solution of choice. But the point is, this gentleman was working on some of the nation's most secret and important programs, but he was doing it from a distance of Hawaii to Washington. And he was doing it not as an employee of the federal government, but as an employee of a contractor, Booz Allen.
So he really breached a duty of confidentiality. He certainly owed that to both to Booz Allen and to the government in going to the Manchester Guardian and spilling the beans. Now, what actually did he tell the Guardian?
He broke all of the rules of his employment. And he did it allegedly on the notion that following a higher calling, he believed the NSA shouldn't have been involved in the things that were happening. But there were other ways to deal with this issue rather than take it in the clandestine manner he did and very operationally very clever way in which he bundled up the material that he had created and got it to the Washington Post and got it to the Manchester paper and made it so that they were the ones that determined the pace at which it would appear. So he, in that sense, he hit a 10 strike. But the point is that if he had felt as strongly as he claims he did about the fact that NSA was exceeding its mandate, so to speak, or doing too much, there were other things that he could have done. He could have gone to the Inspector General, my old job, and there was one for the National Security Agency who could have taken his complaint in hand and figured out whether there was any merit to it. But going outside the realm, so to speak, without any condition on what he gave up, that was clearly not up. Not the way to do it.
Well, I think he took the position that whatever was done by the NSA was done in the name, with the authorization, and with the money of the American people and the American taxpayer. And so they were entitled to know what they were paying for and what their government was doing.
Well,
I mean, what's wrong with that?
That's a rather clever but twisted way of looking at it. He signed an oath that he wouldn't reveal classified information.
And you said at one point, I quoted as saying, welcome to the world of fewer secrets. Did you mean our own secrets as citizens, or do you mean the secrets of the government?
Well, I guess I'm thinking that there are so many cross currents at work here, Jim. There's so much information that's out in the public domain. There's so much information that's accessible through the social networks and other ways that it's not the world that I knew during the Cold War, where you were operating against a government that closed down the hatches at every point, where you didn't have available the simplest kind of information. So it's a brave new world.
Let's look at Snowden's revelations for a moment. I mean, among the most shocking was that we had been systematically bugging the cell phones of world leaders of friendly nations, Angela Merkel, Dilma Rousseff of Brazil.
That's
and certainly very embarrassing to the United States government that we were doing this.
I agree with you, and I find it, what I find is sad, is that we felt we needed to gather this information to gain us a small tactical advantage in negotiation, perhaps, or something of that kind. But no, I think, and the idea, and I don't hold me to this, but I believe in all that I have read. It wasn't clear that the President of the United States knew that Merkel was being tapped, and it strikes me that that was an enormously stupid thing to do.
So who is it in the NSA that makes these decisions? Who thought it was a neat idea to bug the cell phone of Angela Merkel?
Well,
and who was it who allowed it to continue?
I think there have been times in the past where there were many foreign leaders that were bugged, not only by the United States, but other able intelligence organizations too, certainly during the Cold War. And I think it's a program that sort of has to be looked at very carefully. I'm not saying there shouldn't be a bug on a foreign leader. Depends on who the leader is, and depends
but a friendly leader?
It depends on what they have to get. No, I'd have trouble with friendly leaders, but I think that the notion of being able to get inside information as to what a head of state is thinking can't be ruled out altogether and arbitrarily. But it's something that when it goes to that level, and especially when it's a close friend, an ally, like Angela Merkel, the president has to know about that. Now, I'm sure you have had friends. I've run into a number of Germans in the period since this came out, and this is hitting the Germans very hard. They do not believe that under any circumstances Angela Merkel should have been her conversations tapped. So we're probably heading into a new world on that too. Whatever might have been excusable in Cold War times to give us a tactical advantage, it may be being reviewed.
Well, there was an explosive reaction in Brazil to the revelation.
And Brazil as well.
We were tapping into the emails of the president,
Yeah,
Dilma Rousseff.
what kind of a friend are you?
And what did we hope to learn from
quite.
tapping into her emails?
I'm sure there were some interesting tidbits, but not worth the risk.
Now, the reaction of a country like Brazil or of other countries may be to withdraw their country from the World Wide Web in order to enhance security. This could lead to the balkanization of the internet.
It could, but I don't think they'll go that far. I think they'll be very cross with us for a long period of time, and they will make it absolutely clear that they just don't want this to continue, but then the ties between the United States and Brazil, and certainly with Germany as well, will override this, and we'll get back to a better state of play. But I think it is an enormous risk to take, that's your point, for what would appear to be a marginal gain.
Now, let's move to domestic spying, because what he also revealed was a massive program of domestic surveillance, a metadata program. And I think that in our law and we've distinguished between international spying, and certainly the CIA does, and domestic spying, which...
There's some language, Jim, in the laws that were passed after 9/11 that gives the NSA colorable right to get domestic conversations, business records in pursuit of terrorists. And it's important for your viewers to understand what metadata is. It is the name of the person making the call. It's the place that it's going to. It's the name of the recipient and the length of the message. It is not the contents of the message itself. And that you have to be very clear on, because in order to go into the message, you have to go to the Foreign Intelligence Surveillance Court, which is a special court set up in Washington, D.C. to take cognizance of these cases where the U.S. government wants to tap the phone or the communications of a terrorist or a spy. It's been in existence for a long period of time. It hears the government make the argument as to the desirability of making the tap. It hears it just from the government side. Nobody's there representing the person who's going to be tapped unless it turns into a prosecution.
So it's not an adversarial proceeding, it's an ex-party proceeding.
It's an ex-party proceeding, and it's also one that takes place, it's secret, and the presiding officer, so to speak, is a federal judge, a judge appointed by the president, confirmed by the Senate, but who's sitting on this special court for a period of time.
But before we get to an interception of the content and the FISA court, and we can certainly want to talk about that, if the government has swept in every one of our telephone conversations without any suspicion whatsoever that a citizen may be engaged in terrorist activity, every email that is sent or received by a citizen, all of which are honorable, innocuous, no crime suspected, no involvement with terrorism, they're learning an awful lot about us.
Well, if they actually get to the point at which they can open up those messages and get at the substance.
Well, before that, if it's just metadata, which metadata means data about data,
yeah, but it doesn't
fact is, I call you, and I call you a number of times in the course of the month.
And
the government knows we have a relationship.
Right.
I call a doctor, I call a lawyer, I call a psychiatrist, I call a doctor who specializes in some terrible disease I don't want people to know about. I mean, there's a tremendous invasion.
You call your girlfriend.
Or I call my girlfriend. That's less honorable.
Right.
But still, it's a tremendous invasion of privacy.
It is, and there's no question about it, and I don't think Americans really focused on it to the extent that it exists until Snowden came forth with his revelations. So we may be in a situation now where we're thinking this through. My sense is that the commission that the president appointed to review this collection program has made recommendations, and they're trying to sort out what should this many messages be taped as a matter of course, or metadataed as a matter of course. That may change, and yet it is important to emphasize that as far as the substance of the message itself is concerned, there is this FISA court protection.
Is there any evidence that a single terrorist attack has been thwarted by reason of the metadata program?
Not that I've seen. And again, you'll just have to, I think it's a very good point to make, but you have to put an asterisk on it, and maybe there's some things we just don't know about. Remember, this was a situation that got the Bush administration, Bush 43, in difficulty some years ago. The NSA was doing this without benefit of law, and they had to scratch around, and it was immediately after 9/11, and people wanted to make sure that Al-Qaeda, if they were contacting American citizens, somebody in the government knew about it. There was a very different attitude towards this. Now it's become a mammoth program, and it's one of those situations that Donna Priest wrote about in Top Secret America. We're doing it at the cost of $16 to $18 billion a year spent on counterterrorism, so-called, and it's an enormous program. And what you're suggesting is perhaps it's too much, and it ought to be revised.
Isn't there a secret law that was enacted for the FISA court where they could tap domestically without court approval? Did you hear anything about that?
No, but it's not. I think you're thinking of the same thing. It is tapping domestically, And they do have court approval in the sense that they have the FISA court approval, but it's in the cases. It started out. It's an old piece of legislation after the United States versus Keith case where they had to get taps for this. It started out in the intelligence area and then grew after 9/11 to involve terrorism as well. And so it's out there.
Now, you're an old CIA guy, and certainly one secret that the CIA guards very closely are sources and methods of intelligence. The CIA uses human intelligence, while the NSA uses SIGINT.
Well, and the CIA is also involved in technical means of collection. It runs the overhead reconnaissance program and that sort of thing. So you're right.
Yeah, and but certainly neither the CIA nor the NSA wants sources and methods of intelligence to be out there. If our enemies know that we have a metadata program, they can be very careful about whom they communicate with and how they communicate. So in this sense, did Snowden damage the national interest?
No, because I think people whose business it is to know what the U.S. government is doing knew that by virtue of these, as I say, early instances of capturing intelligence and terrorist conversations and then enhanced by legislation passed in the wake of 9/11, knew that the U.S. government had the possibility, the authority to do this sort of thing. I'm sure they were surprised at the extent that the NSA is engaged in it. And the question you put as to whether we have any indication that anything successful has been learned as a consequence is a relevant one. And it's one that the oversight committees of the two intelligence, of the two houses of Congress have got to go into, it seems to me, to reassure us as citizens. But I think anybody that was anxious to recruit Americans as spies knew that they were coming against an arsenal of defenses.
Let's get back to the FISA court, as I said we would. The only lawyer present before the FISA court is the lawyer for the government, who's arguing that he needs this interception for national security reasons.
That's correct, and it happens.
There's no lawyer there representing the privacy interests of those that might be involved.
Not at all, and it's a closed proceeding in every way. It takes place in some space in Justice Department that is devoted to the judges, the Article III judges that are sitting on these cases. And these people, as you know, Jim, you practice law. These people they're coming from regular district judge responsibilities, and they're going back to them, and they're not going to let the government just come in and pull the wool over their eyes. And so this batting average, which has been very high for the permission given to go forward in these cases, is high because the surveillance court sends a lot of these cases back. They say to the government, do your homework.
Well, but
give me a greater justification as to why you see X or Y as a terrorist.
But the datum is that they approve 99% of the applications.
No, it's high, but he said that doesn't obviously include all those they send back and say, sorry, don't bother to send this up. Don't bother to send this up unless you clean it up.
But do you think that to make it a fair proceeding, there should be someone there representing the privacy interests of the people affected by the surveillance?
I have a bit of difficulty with that. I think that might just gum up the works.
Because, for example, I mean, suppose they say they want to run a surveillance on A because the metadata shows that A knows B, and B knows C, and C knows D, and D knows E, who may be a terrorist. Now, how long do you go in the chain, and is there a lawyer there who's going to point out that you're invading the privacy of maybe 3 or 4 people?
There's not a lawyer there, and I guess my answer would be...
Should there be?
I don't think so, because I think the judges that hear that kind of a strung-out chain of logic are going to say, they're going to say, come on, if this is how thin your connection to what you consider to be a terrorist or a spy is, we don't think so.
Now, 2 federal judges have passed on the metadata program as implicates domestic surveillance. A judge in Washington who thought it was probably unconstitutional, and a judge in New York who sustained it. Do you have a view as to the constitutionality of the metadata domestic surveillance program?
I have a view, but I don't
you want to
think...
share it with us?
Yeah, I think that under the circumstances in which it was originally conceived, I think it's okay. Because I think there are checks and balances. Like, obviously, as you well know, this is an exception, and one that has to be very carefully scrutinized to the Fourth Amendment rights of individuals. And so I don't think if they go too far afield, they've got to be snapped back. And I also think that in the period, here's what I really feel in a positive sense. We're not the country we were before 9/11. We've done an awful lot to shore up domestic defenses. But I hearken back to the statement of the first director of the National Counterterrorist Center, created in the wake of 9/11, Eric Leiter, a lawyer, very good lawyer, and he said, having gone through a couple of years of policing up this stuff, he said, and following the trails that were of potential terrorist activities, the United States has to develop a certain resilience to these things. We're stopping an awful lot of foul balls before they get operational in the United States. But it's always possible that one will get through. And if it does, it will not be the end of the world. It'll be tragic, it'll be momentous, but 100% you can't ever be sure is what he was saying. And he was saying, back down a little bit. We don't have to be as uptight as perhaps we were deservedly after 9/11. Things are better in terms of defense. And I think it's going to be on that basis that as the president reviews what's going on with respect to the NSA and these metadata controls, he can say, well, I don't think we need to do it to that extent.
Because the national security doesn't require it.
It really doesn't. Because
and he should think through the privacy concerns at the same time.
And he should think through the privacy concerns. And the other question you put, well, how successful have we been so far? The main thing to
Zippo.
Zippo. Well, that we know
Nothing.
Of. That we know of.
Well, the commission that the president appointed said they couldn't find a single instance.
No.
Where a terrorist attack was
and on the other hand, we've had some remarkable successes on if you see something, say something. I'm mindful of that incident. I think I'm correct in reporting it several Thanksgivings ago when that attack took place in Mumbai, remember?
Yes.
At the Taj Hotel. We first learned about that from a Harvard University Medical School associate of the Mumbai government who was going back to his hotel room in that same hotel, saw the violence that was taking place, went back to his room and twittered Boston. I mean, the point is there are so many ways in which we communicate these days. We're picking up a lot of information on bad stuff without having perhaps to gather all the mega data that we have been.
Well, it's interesting. You had Judge Leon in the District of Columbia who thought the metadata program was Orwellian, invoking the novel 1984.
Right.
Big Brother is watching you.
Big Brother is watching.
And he distinguished this case of Smith against Maryland, which was the Penn Register case, where the Supreme Court said that it's not a search and seizure because third parties are voluntarily given the information. When I make a phone call, I know the phone company's making a record of it for billing purposes or technical purposes or whatever.
Not listening in.
And he said, so there's that's right, no expectation of privacy in the fact that I'm making the phone call.
Right.
But then he goes on and he says, times have changed. Just as you say, times have changed since 9/11. Times have changed. And there is an expectation of privacy on the internet. And there is an expectation of privacy when I call my girlfriend or I call my psychiatrist or I call my lawyer. And we've become a much more complicated society, and we communicate electronically as opposed to face in most of our transactions.
Well, I don't.
So, do you agree with his reasoning?
I don't want to appear to be cynical, but the fact of the matter is, I'll speak personally, my expectation of privacy on the internet and in several of the ways that you mentioned is not great, because I think it can be scarfed up. I don't believe it should be. I think $16 to $18 billion is too dadgum much money.
That's how much we're spending on it?
That's what we're spending on counterterrorism of all kinds since 9/11, and it's a horrific number.
Including pervasive spying on Americans.
Correct.
So, so what do you think we should do by way of reform? Should we abolish the program?
No, but I think we should cut it back substantially to the areas in which we don't have any other coverage and where we really genuinely suspect the kind of contacts that we're interested in would take place. The point is, the NSA is so capable and has such a technical reach. I mean, this is an organization that with its forebears goes back before the Second World War. And this group of 6 that work.
It goes back to World War I, but I'm afraid we have to stop. But I have a question for you, Fred Hitz.
Yes, sir.
Were the Snowden leaks good for America?
No.
No, they were not good for America.
No.
And why is that? Tell us.
Because I think there was a better way to have done it.
Better way to have done it.
Yeah.
Fred Hitz, thank you so much for coming by. This has been just fabulous. And thank you for coming by. Tune in next week for more conversations in the digital age. I'm Jim Zirin. Please visit our website at www.digitalage.org, even if somebody is listening. And for the digital age, for conversations in the digital age, good night and all the best.